I should have said this at the beginning, but I didn't. I don't mind being interrupted with questions, personal abuse, objections, throwing things whenever you feel appropriate, but more accurately, questions, things you don't understand or disagree with anytime. So a little bit of history, as I said, of American rights adjudication. To repeat, judicial review is not specified in the document. There is nothing in the Constitution giving judges the power to strike down legislation as being unconstitutional. And indeed, it's certainly possible to have a constitution, a written constitution without judicial review. Much of Western Europe has that tradition. Much of Northern Europe still operates that way. There is virtually no effective judicial review in Scandinavia, in the Netherlands, in Switzerland, and in some number of other places. So it is, in theory, possible. It's not specified in the document, but in 1803, judicial review was created in the United States in 1803 by a Supreme Court case called Marbury versus Madison. John Marshall was the Chief Justice, and the underlying dispute was about jurisdiction. The underlying dispute was highly technical. What is important today about Marbury versus Madison is that it established the power of judicial review. That's not what was important about it then. What was important about it then is that John Marshall asserted the power of the courts to tell the President of the United States, the executive department, what to do. The view was widely held at the time that in a system of separation of powers, the courts did not have the power to tell the executive department, the president, what to do. Much of this decision was political. Madison was James Madison, later to become president. He was Thomas Jefferson's Secretary of State. John Marshall, the Chief Justice, and Thomas Jefferson were bitter political enemies. And Marshall wanted to establish the power of the courts to tell the president what to do. So Marbury versus Madison, first of all, established the power or asserted the power of the president, of the courts to tell the president what to do, to issue orders to the president. But because Marshall was a good politician, he recognized the reality of the fact that in telling the president what to do, the president might not comply. After all, the Supreme Court does not have an army. There was a very real risk that in 1803, a judicial order issued to the executive department would be met with the response of no. What are you going to do about it? Or in the language of the schoolyard, at least my schoolyard, make me. So Marshall recognized that this was a real risk. So having asserted the power of the president, of the Supreme Court to tell the president what to do, the court then went on to say, but we do not have the jurisdiction to do so, because the statute that gives us jurisdiction is unconstitutional. That was an afterthought at the time. It was a political strategy at the time that enabled Marshall to assert the power of the courts to give orders to the president, but then not actually have to do it. At the time, Jefferson was furious about the assertion of the power of the courts, and he observed accurately that given that the court had no jurisdiction, all of this was unnecessary dicta, that is, statements by a court of no legal effect. After all, if the court has no jurisdiction, what's the point of saying, we do not have jurisdiction, but by the way, if we did have jurisdiction, we would have the power to tell you what to do, which is essentially what Marshall did. That got Jefferson angry, but the implicit message or explicit message that the courts have the power to declare acts of Congress unconstitutional is what has in fact endured. So there is now the power of judicial review. It was not used again for another 51 years. The second time the Supreme Court declared an act of Congress unconstitutional, it's 51 years later in the infamous Dred Scott decision, in which the Supreme Court said that slaves were property and not people. The Civil War ensued 7 years later, but Dred Scott was only the second case in which the power of judicial review was actually used. Now, the Civil War is important for a number of reasons, sort of in American constitutional history. At the end of the Civil War, there were 3 amendments to the Constitution. The 13th declared officially declared the end of slavery as a constitutional matter. The 15th gave everyone, regardless of race or color, the right to vote. But most importantly was the 14th Amendment. The 14th Amendment was the first time that there was a constitutional guarantee of equality. Particular phrase is equal protection of the laws is in the 14th Amendment. And the first